You don't have to have children in the school system or in the Palo Alto schools to care about the juvenile justice system. Vital issues swirl around the juvenile justice system. Why is it so secretive? How do we handle a kid that does an adult crime? Why is there still so much disproportionality in the juvenile justice system when we talk about who is detained, especially when we talk about Latino youth? What is the right balance between rehabilitation and the odds of recidivism? Why 7 years ago were there 300 people, the average daily population in juvenile hall, why were there 300 people in juvenile hall, and today there were 90 people in juvenile hall? What does that mean? These are good questions, and hopefully tonight we can talk about those questions. But for the record, I do have kids in the local school system in Palo Alto. And for all these sort of academic questions that we might hear or things that you hear about Stanford, there's just one sort of question that I have every day. Are my son and are my daughter safe in Palo Alto and when they go to school? Now, as with all criminal justice matters, we need to be careful about what we say. So, if some of you ask questions about specific cases, there's sort of a ground rule. We may not be able to discuss the specific cases because the law prevents us from discussing specific cases, but we'll try. You might be surprised how much of the juvenile justice system is open to the public, and we'll tell you about the different rules that apply to that. Do you all know that with really serious crimes, it is open to the public, and you can go and watch a juvenile court proceeding just like you would watch an adult proceeding? In other ways, though, the juvenile justice system could not be more different than the adult criminal justice system. And that's because it's premised on a completely different principle than the adult criminal justice system. The principle of the juvenile justice system is to help rehabilitate, to repair. It's designed to try to help a young person find their way back out of the juvenile justice system into society so that they can become productive members of the adult community. Yet, it's also a system that struggles to deal with the chaos and mayhem of crimes that we deal with in adult court. The terror that someone feels when a gun is pointed in their face is the same terror whether the person pointing the gun at them is 16 or whether they're 22. If a teenager commits a homicide, it's just as senseless and it's just as horrible as if it were an adult that committed a homicide. So how do we manage our role in this system when they're based on different principles? How do you address these challenges? Imagine the difficulty. It's a challenge. So on that note, I would ask that you be patient with us if we're not able to speak for other agencies or other districts that aren't here. Our role is carefully delineated in the criminal justice system, and while we are players in the criminal justice system, we're not the only players. To help you understand more about what happens in the juvenile justice system, I'd like to introduce two experienced and dedicated public servants who work on the front lines. Nate Wandruff is an investigator with the DA's office who served 20 years for the Mountain View Police Department. Right now, he works for the DA's office as an investigator, and he works on the domestic violence team, the firearms training unit, our officer-involved incident team. As a former Mountain View police officer, he's responded to many, many cases involving juveniles. I'm really pleased to introduce LaRon Dennis to all of you. She's been with the DA's office for, I think, about 5 years now. And she's very young, but I want you to hear about her experience prior to joining the DA's office. She was a professor teaching juvenile law at USF Law School. She served as a consultant training justice system partners on the use of risk assessment tools and the implementation of evidence-based practices throughout California. She served as a delinquency law and policy attorney for the California Judicial Council. She was a senior program associate at UC Berkeley's Center for Criminal Justice at Berkeley's Law School. She was a deputy legislative counsel for the legislature in Sacramento. And for 11 years, she was a juvenile probation officer in Santa Clara County. And she will tell you about the significant role that juvenile probation officers play in the juvenile justice system. She's also co-author of the leading treatise on juvenile law for the whole state of California, which is a book called Sicer and Cumley, California Juvenile Court Practice and Procedure. So really take advantage of the fact that there is a national expert in juvenile justice here to give information and try to be helpful and answer questions. But before we get into the substance of the program, I'd also like to introduce the third person on the panel right now, and that is Elena Kadvany. She will be serving as the moderator for tonight's panel. Elena is the youth and education reporter for the Palo Alto Weekly. She covers the Palo Alto Unified School District, Stanford University, and she has been reporting on sexual violence, bullying, and other school safety topics for the past several years, including the school district's response to those topics, about Stanford's handling of sexual assault, and of course she wrote extensively about the Brock Turner case. Her work on this subject has been recognized by the California Newspaper Publishers Association and the San Francisco Peninsula Press Club. She is a Menlo Park native. She holds a bachelor's degree in Spanish with a minor in journalism, and she attended the University of Southern California. All of us are very pleased that you've come out tonight and asked us to speak with you. For many of us sitting up here, this isn't just professional, this isn't just philosophical, it's actually personal. So we're here at your invitation, and we're here as public servants, but we're also here as your fellow citizens. We're here to listen and learn and not just to teach. So with that, Elena, would you like to share any comments about how you plan to moderate this tonight?
Sure. So thank you all for being here tonight. We're really thrilled to co-sponsor this event with the DA's office. Someone will be coming around with index cards for you guys to write questions on for the panelists. So there's going to be some short presentations. I'll remind you again about asking questions, and then I'll be asking the panelists a few questions myself, and while that's happening, questions will be brought up to me, and there will be time at the end, about 30 minutes or so, to answer your questions. So, and I think we'll be collecting cards throughout the evening, so if something comes to you later on, feel free to flag someone down and we'll get your question up here.
So the one thing I will say about that video, which was made probably about 10 years ago, is there was a reference to when a youth might be committed to a state level facility till the age of 25. The law changed a few years ago now, and that's just 23. Okay, so I'm going to go through just a few, hopefully not totally boring, statutory and legal references, just because I think it will help explain a little bit about sometimes what happens, why we do what we do, the way we do it. So first of all, Welfare and Institutions Code Section 602 is the provision that brings a child under the jurisdiction of the court. So if a child were to break some sort of law, like an adult would break, we don't say that they broke the law. We say that they committed an offense that will bring them under the jurisdiction of the court. As Jay mentioned in his remarks, the juvenile justice system itself is based on the premise that kids are different than adults. And so the philosophy of the juvenile court is found in Section 202, and it's called, by those of us that work there, the purpose clause. Section 202 tells everybody what the purpose of the juvenile court is. And as you can see here, I won't read it all, it's basically to make sure that kids are held responsible for their delinquent conduct, but that we also take into consideration public safety, protecting victims, and while we're trying to do what holds the kids accountable and is in their best interest, that can, on occasion, include punishment. So some of the considerations when the court and those of us in the juvenile courtroom are handling cases, we try to take into consideration the three key things: public safety, the importance of redressing any injuries to a victim, and ultimately what is in the best interest of the minor. I want to give you just a quick shorthand comparison between the criminal justice system and the juvenile justice system. First of all, in criminal court, the purpose is to decide whether or not someone is guilty or innocent, to punish the guilty, and protect society. And criminal court hearings are open to the public. The juvenile court is different. It's trying to determine whether or not the allegations are true or not, but even a sustained petition is not considered a conviction. We also serve to preserve and promote the welfare of the child, to provide care, treatment, and guidance that are consistent with the best interests of the minor as well as the public, and most juvenile proceedings are closed to the public. You will find in this particular section of the Welfare and Institutions Code a list of the crimes that when a minor is alleged to have committed one of these, this hearing will be open to the public. So some of the common ones that would be open to the public will be murder, the forcible sex crimes, felony assaults, the really serious crimes. Those kinds of hearings in juvenile court will be open just like in adult court. The public in general and even the press can attend these hearings. And even cases that are supposed to be closed to the public, if the court believes that the public has a legitimate interest in a case or the work of the court, the juvenile court judge can decide to open a hearing to the public. However, the one exception to a closed hearing is even the victims of that crime can then attend that hearing. So even though the hearing itself would normally be closed because it wasn't one of those really serious crimes, if you're the victim of even a minor offense, you have a right to be present, and you can have two support people attend with you. So the juvenile justice system is a little different in another sense, and that is when an adult commits a crime, the police department that investigates that crime brings the police report directly to the district attorney's office. In juvenile court, that's not the case. The police reports make their way to the juvenile probation department first. We like to call the probation department the gatekeepers. They are entitled under a statute to handle all misdemeanors. So they don't have to bring misdemeanor police reports to the DA's office for handling. They can choose to put the child on informal supervision or informal probation without ever bringing the case to the DA's office or to the court. They can settle cases out of court and take absolutely no action whatsoever. They can do diversion, they can issue a verbal reprimand. They have all kinds of tools at their disposal that don't require formal court intervention or review by the district attorney's office. And a little known fact is anybody can actually file an application for a petition with the probation department. Parents whose kids are out of control or any other member of the public, if they want to file an affidavit with probation and request intervention, they can do that. Although in all the years I've ever done this job, that's never happened. So the DA's role in juvenile court is we file the petitions, which is in the video, it's the same thing as filing charges or filing the complaint in adult court. And as the video indicated, there are timelines depending upon the type of offense that we're talking about. Generally speaking, it's going to be within 48 hours. With very serious offenses, it can be a little bit longer. We can reject a case if we get a police report and we don't believe that the elements of the crime are there, or we don't think in the interest of justice that it would be appropriate to file charges. We can reject a case. One of the things we can also do is get an arrest warrant. And if we get a case that we believe should be a misdemeanor, we can refer it back to the probation department for them to handle it. So I'm going to talk a little bit about, as Jay mentioned, some of the things that people find secretive about the juvenile justice system. One of the first things that people find interesting is that in order to commit a crime, you have to fall into certain categories to be responsible. And one of them is that the statutes presume that if you're under 14, you're not capable of committing a crime. You have to be able to understand that what you did was wrong at the time that you did it. You have to appreciate the wrongfulness of your actions. And it is one of the things when we file charges against someone under 14 that we have the burden of proving that the child appreciated the wrongfulness of their conduct at the time. Another thing that people often find confusing and challenging is related to the confidentiality of juvenile proceedings and juvenile records. All of the juvenile court's records are confidential. Law enforcement can generally share information amongst themselves, but in order for anybody else who isn't specified in the statute to be able to have access to juvenile court records, they have to file a petition with the juvenile court, and they have to be granted access by the juvenile court. Even victims of crime are not entitled to copies of their police reports when the offender was a juvenile. If you are the victim of a crime by an adult, you can walk right into your local police station and ask for a copy of that police report. You can't do that in juvenile court. You have to petition the juvenile court for access to that report. The juvenile court judge makes that decision, and when they do so, they're weighing the needs of the minor and his confidential privacy rights to the interest in releasing it. What is the reason that someone wants access to it? And it's ultimately the judge's decision to weigh those things. And it can be a somewhat long process and requires a variety of forms. There is an exception for providing information about certain things to schools. If a petition has been sustained for a felony or certain misdemeanors, and some of them are listed there, battery, vandalism, certain sex offenses, the court is mandated under the statute to notify the superintendent of a school district of that particular event. The code, however, is very clear that it goes from the court to the superintendent, and if necessary to the principal, counselor, teachers, and administrators, but only if the knowledge of the offense and the disposition of that case is needed to work with the minor at school or to protect other vulnerable people. And it's a misdemeanor for any of that information to be disseminated to anybody else. There's also a provision that allows school police or school security officials to notify the superintendent if a minor has been found to have committed certain specified offenses or controlled substance offenses. And the offenses that I refer to there sort of generically as 707B offenses are the very, very serious offenses that were on the previous slide. Things like murder, assault with a deadly weapon, forcible sex crimes. And once the school police or security give that information to the superintendent, it's only very limited things that they tell them, what was the offense and what was the outcome. And again, it's only to be disseminated to the administrators and the teachers who have direct supervisory roles over that student, and only if it's needed to work with the student or protect other vulnerable people. And again, it has to remain confidential, can't be disseminated, and it's a misdemeanor to do so. Similarly, there's another provision that if a minor is taken into custody because of a crime against property or a student or personnel of the school district, that information can be exchanged between law enforcement and the school district superintendent and the principal where the minor is enrolled. And lastly, the things that I think also frustrate people and they don't really understand is when can a kid have their record sealed? So that law is sort of in flux right now, but as it stands, once you turn 18, or it's been 5 years since you had your juvenile court case, you can petition the court to seal your records under this provision 781. It's also possible if you're on probation and you do a satisfactory job of performing on probation, you can ask the court at that very moment to dismiss your case and seal your records. For now, if a petition has been sustained for one of those 707B offenses, the really serious ones, some of those are listed there, you cannot have your record sealed. However, there is a bill pending, I believe it's been sent to the governor, which will change that, and those records will also be eligible to be sealed in the future. So, with that, I am done with my presentation, and we can go back to questions.
I thought it might help to start with sort of an understanding of the landscape of juvenile justice in this area. And I was wondering, what are the most common juvenile crimes in Santa Clara County, and if Palo Alto differs from the overall rates in any way, or what kinds of crimes?
Well, I can't say that I can't probably differentiate for you Palo Alto to Santa Clara County, since our data is collected in the aggregate. The most common offense so far in this year is residential burglary, followed by robbery and auto theft.
Although I think if you want, we can try to get that information.
Absolutely.
We just don't have it right now in terms of this community versus other communities.
Sure, okay, thank you. And do the police exercise more discretion in handling juvenile cases and allegations which might result in lower charges being filed against juveniles in Santa Clara County?
You want to talk about how you think police respond? Maybe it's different.
Except for some minor procedural differences, and they're relatively minor, a police officer typically would handle any investigation the same way, regardless of whether or not the defendant or victim was a juvenile or not a juvenile. Particular attention is paid to juvenile suspects because police officers are required by law to advise a juvenile suspect immediately upon contact. For instance, immediately upon contact of their rights under Miranda, because it's presumed that maybe a juvenile is not as well versed in the law, and we want to make sure their rights are preserved and they're well advised. With the exception of, like I said, of the exception of the procedural differences, the criminal investigations handled essentially the same.
And I think maybe in filing charges, I like to think that it is certainly something that we consider when we get a case. We would obviously want to be sure that victims have their losses covered and that the public is protected. But clearly when we're talking about juveniles compared to adults, there's lots of other things that go into consideration.
Mm-hmm. And how does the district attorney's office handle crimes that are committed on school campuses? And what is the relationship like between law enforcement, the DA's office, and school administrations in those kinds of cases?
Well, Nate can speak to maybe how they respond when they go to a campus, but I think generally speaking, where a crime occurs doesn't matter so much. When we receive a police report, because I won't, as the DA, get information directly from the school. It's going to come from the police report that will have made its way through probation to me. So for our purposes in terms of filing, I don't think it matters particularly where it occurred. I do think in recent years there's been a move, maybe in lots of places, but I think specifically in Santa Clara County, where offenses can be handled appropriately at the school level through school resource referrals and on campus with education code type discipline. I think schools nationwide, but I think particularly in our county, are trying to move in that direction. But I can let Nate speak to coming to campus to take a police report.
Well, my role as a DA investigator is quite different than when I was a patrol officer. I did used to push a patrol car. But at the time, things we paid particular attention to, and I know are still emphasized in training of patrol officers, is sensitivity to the environment. So with respect to responding to a crime on campus, we would consider whether or not we could conduct the investigation discreetly. And then we would think about things like, who do we need to notify? I think this probably enters into an area where people are confused about why the cops do things the way they do them. Some considerations we have are who the suspect is. Is the suspect another student, or is the suspect, you know, in rare occasions, a staff member? Is the suspect an adult that has nothing to do with the campus? Where did the crime occur? And what other outstanding suspects there may be. We have to consider a lot of different things. And so maybe, for instance, it may not be the best technique to storm onto campus, walk into a classroom, and yank a kid out of a class. That may not serve our investigative purpose, and it may be very disruptive to the campus. Examples are endless, but procedurally, we have to be very sensitive to those things. The other thing is as the police in general, as law enforcement, we view the school staff, everyone thing from administration down, as being part of the team trying to accomplish the same goal. And part of what I was concerned with, and I was a training officer in a uniformed capacity, part of what I made myself pay attention to and what I trained my recruits to do is be sensitive to whatever potential impact our investigation could have on this kid. A suspect truly means that. It doesn't mean they did it. That means they're being looked at. So we know, we all know, those of us who have kids and those that are wherever a kid know that, you know, rumors can be extremely devastating to a school-age kid, and we need to be sensitive to that. The other thing is we don't want to compromise the investigation anyway by sometimes it's not the best technique to go to court or go to a school and say, hey, the cops are here. Does anyone know about this crime that occurred? So we have a lot of considerations. I don't know if that answers your question as succinctly as I could have, but I think there's a lot of mystery, and we can get into that a little bit later, but a lot of mystery about why we do things or why we don't do things sometimes when it has to do with the crimes that occur on campus or related to a school.
And what about during the investigation phase? How much information is shared with school administrators, for example, and vice versa? You know, if they're conducting their own, you know, disciplinary investigation, or if it's a sexual assault, a Title IX investigation, is there open communication between police and the school, or is it sort of like they're happening on separate tracks?
I'm so glad you answered. That's a great question, and that's one I actually prepared for.
Good.
So, I knew this would come up, and if I was a member of the community or a parent, I would want to know those things. And a lot of times, even as just not from a law enforcement perspective, but just somebody watching the news or listening or reading an article, it's confusing about why law enforcement isn't telling us more. And one of the things we have to do as law enforcement officers and as the district attorney's office, we have to make some difficult decisions. And a lot of times they're unpopular. I just want to talk about our priorities as law enforcement. Number one, it's public safety, and within that group, the safety of the victim is number one, followed very closely by the safety of the public or other potential victims. And of course, we have to think about the safety of the offender, and then of course, the safety of our officers as well. But part of some of the confusing and sometimes frustrating decisions that we have to make involve not telling the public things, and some of the reasons why we may elect to do that, in no particular order. We have to consider, number one, who, like I mentioned before, who the defendant is, who the suspect is. So particularly in sexual assaults, and I've done 3 tours in sexual assaults, and I know that in my experience, particularly sex crimes involving juveniles can be tricky. We don't always know who the suspect is. We don't know necessarily how many victims there are. And depending on who the suspect is, may be a real telltale sign that we could have a much larger victim population. For instance, in cases that I've worked, if you have a case where where the primary suspect is the soccer coach or the gym teacher, that case is going to be handled differently than if we have a known suspect that's not related to the campus. And sometimes we withhold information for all those reasons. In other words, we don't want the suspect to know, we don't want to compromise any potential witness or victim interviews we may do. We may not know where the suspect is. And there's a lot of reasons why we don't necessarily broadcast all that we're doing. And I guess I'm here to make a pitch and just reassure everyone that there's usually a very good reason why we're not forthcoming with information in those types of very sensitive investigations. I've seen it go both ways. I've felt the pressure of people wanting to know more, and like I said, if I was a member of the community and I wasn't involved in an investigation, I would want to know those things too. If it had something to do with my kid, I would be as insistent as anyone else is that we get to know more. Just be aware that the safety of the kids is the #1 priority, and while it may seem like we're being evasive or holding back, there's almost always a very sound reason for us to be doing that.
Mm-hmm. I think that was a question that came up in the community after a sexual assault was reported at Palo Alto High School this spring, and that really became a topic of concern for many parents of, if something like this happens, why are we not informed about it? So are there certain circumstances in which the police or the DA can release public information if, the safety of a campus is compromised or there are concerns like that, or is it up to the school district? How does that work?
I think we both should answer, but she's certainly the legal expert about that. But from my perspective, look, this is a source of great frustration, and I absolutely can sympathize with any parent or just a community member who would express concern that they didn't know about an offender in their presence. I know it's frustrating to you. It can be very frustrating to me as a law enforcement officer. Trust me, the visceral reaction I have to that when I hear there's a sex offender at a school is just like many of you probably are having right now. Like, we need to know that right now. With that said, I'm required to act within the confines of the law, and LaRon can get into that. But I'm also not a legislator. I'm a public safety person, so I feel sometimes as frustrated as you or more, and feel like I'm being restricted from what my gut's telling me to do. But there are, as LaRon will get into, we have to act within the confines of the law.
Yeah, so I think that obviously the difficult thing is, as prosecutors and being concerned about public safety and protecting victims, we're very aware that more information seems like it would be better. And unfortunately, we are bound to follow the statute, which, as I outlined up there, is very clear that that information is confidential. And in most cases, it's not going to be provided to the school until after the person has had a petition sustained and after they have been through their disposition or sentencing hearing. And even then, the information that's given to the superintendent is extremely limited, and he can only, under the law, provide it to the people on the campus who need it in order to work with the minor and protect other victims, potential victims. So, as difficult as it is, I would say you could start in Sacramento by changing the laws if you'd like, but we are very limited in the kind of information that we can give.
So under those circumstances, if a student or a teacher is found to have committed a forced sexual offense, one of those most serious crimes, or any of the other crimes, whose obligation is it to ensure the safety of the campus?
Well, I think the school district obviously is always wanting to ensure the safety of its students, and they will be provided by the court with the information about what has been sustained or what the charges have been found to be true. But it is ultimately, obviously, it's the school district's responsibility, I think, to protect their students. We clearly, as law enforcement, are also interested in protecting the public in general.
Is it, if I could ask a follow-up question, is it the mere filing of a 707B offense in juvenile court? At that point, they're not confidential, correct? It need not be once it has been sustained or proven true, but once a serious crime that may have been committed, in Elena's question, once it's been committed and we have filed juvenile charges, then it is public, so to speak, correct?
The hearings are public. The juvenile records, for all intents and purposes, are still confidential. So if you want to come to the hearing, you could come to the hearings. They're open to the public. But the information isn't going to be transmitted in the form of a notification, so to speak, by the court to the superintendent until we've already gone through the sustaining of the petition and the disposition.
We got a question about legal representation. Should all juveniles have legal representation? And I also had a question around, oh, you need them? Oh, okay. Can everyone hear me? Is that better? Oh. Okay. So we got a question around right to representation. Should all juveniles have legal representation? And also, if families are unable to afford, private attorney, are there public defenders that have specific experience in juvenile crimes?
Should I use this? Is that better? So in my opinion, yes, all kids, anybody should have legal representation. I think certainly if I got in trouble, I would want an attorney. I think you would be unwise to ever go through the court process without an attorney. And Santa Clara County is blessed with having a really wonderful juvenile public defender office. The attorneys are trained specifically in juvenile law, and frankly, there is a new state rule of court and a statute that mandates that attorneys who represent juveniles in juvenile court have to be trained in particular areas of the law, adolescent brain development, just sort of all kinds of things that you would want to be able to, trauma, exposure to all kinds of unfortunate life situations that sometimes affect the way that kids behave, the fact that they're not as mature as adults. All of those things are things that defense attorneys who practice in juvenile law have been educated on.
And how does the district attorney's office handle juvenile crimes that happen off campus but might affect a campus, like cyberbullying, a sexual assault that occurs at a party off campus, things like that, that will probably affect students at the school, but it didn't actually happen at school? Is that the same thing as it happens wherever it happens? Mm-hmm. Okay.
Yep. Yeah, we wouldn't handle it really any differently. We would investigate it and prosecute it, whether the persons being targeted were on a school campus or in a Boy Scout troop or down the street.
And if a school district became aware of a criminal allegation that perhaps happened off campus, what are the school district's obligations to inform law enforcement, and vice versa? If the police get a report about it, do they have to inform a school district?
Well, if the school people become aware of an incident that happened to a student, they're mandated reporters. So if somebody has been assaulted or abused, they're probably going to report it to law enforcement or to Child Protective Services, depending on what the offense was. And I'm assuming that the law enforcement, Nate could speak to this, but I don't necessarily think that they're going to go to the school to tell them that they've heard that some off-campus event might have affected one of their students. But
so I don't want to speak about any. My job here is not to evaluate what a law enforcement agency may or may not have done, or to speak necessarily about hypotheticals. And it's probably not the right environment for war stories. But I can tell you, in my experience, these cases can become pretty convoluted and complicated with respect to management of who we talk to and where. So, for instance, I've responded to a case I can remember where there was an offender this was a junior high school, so right, 7th and 8th graders. There was one student that had sexually assaulted several other students. But as an investigator, one of the things that leaps to mind is, okay, this is a 7th or 8th grader that's acting out. What else is going on? And it turned out that there were adult offenders involved in this. So when the inevitable press coverage came, we spoke a lot about the adult offender that occurred off campus, but spoke nothing at all about the conduct on campus, because the offender for the allegations against that offender was a juvenile offender. So we couldn't confirm or deny there was an investigation going on at all because of our statutory limitations. So it can be somewhat involved. Mm-hmm. And once again, that's one of the reasons why sometimes we approach things the way we do, and it gets confusing for people because we sometimes don't really know what we're stepping into when we get there.
Mm-hmm.
A lot of times there's more to the story.
we got a question about memorandums of understanding between school districts and police departments. Can you explain what that is and how that works?
Well, I am familiar with memorandums of understanding. I'm not aware of any between a police department and a school district. I understand there may be one in progress now, but I can't speak to that. I'm not familiar with
Okay.
that.
Let's see. On the flip side of things, if a student has been found to have committed a crime, what rights do they have to public education? Are there even conditions of probation that might require them to still attend school, for example?
Yes, as long as they're under 18, one of the probation conditions imposed upon them is going to be that they continue to maintain some sort of an educational or vocational program that's appropriate for their needs.
Okay. And this is a question for the audience for you, LaRon. What aspect of the juvenile system, in your experience, is the most impacted by the race of the youth charged, i.e. in charging, sentencing, conditions of probation, et cetera?
Which part of the system is most impacted by race? Well, I mean, I think the studies are pretty clear that actually the deeper into the system you go, the more impact is felt by race. Unfortunately, as Jay mentioned in his opening remarks, in Santa Clara County, we do have definitely a overrepresentation of Latino youth in our system, in our detention facility, in our petitioning. It's just a fact that it exists. But I think the studies generally show that that disproportionality only gets more and more such the further you go into the system.
And how much influence does the district attorney and or the probation officer have on a judge's final sentencing decision?
Well, ultimately, it is probation that recommends to the court what the final disposition or sentence should be. I think how much of a role that plays in influencing the judge depends on the judge. It also depends on the probation officer. I'm sure for all of you, you have colleagues, you have people who work for you or people for whom you work, and there are some people you know do a really good job at their job and you respect them, and there are some people that maybe don't do as good a job at their job and you don't respect them quite as much. And I think fair to say that there are probation officers, there are DAs, there are public defenders who are more respected than others, and so their opinions probably sway the court more than others. But it is ultimately the probation department that files a formal probation report with recommendations for disposition or sentencing.
And what kind of factors do probation officers consider when creating those reports and their recommendations to judges?
Well, I think the Welfare and Institutions Code spells out many of the factors that the probation department is supposed to consider, but there are things like the seriousness of the offense, the effect on the victim, the minor's previous history of delinquency. Is this a person who's been before the court many times, or is this the first time? Do they have a good support network at home and in the community? How do they perform in school? Do they have psychological or mental health issues that might need to be addressed? And do those things mitigate the disposition? Exposure to trauma, child abuse, substance abuse. I think our probation department in particular, I think, does a really good job of providing to the court a full picture of the kids that they see.
And then ultimately, we're in an adversarial system, and you might hear prosecutors say that the defense attorneys are having too large of an influence on the judges, or the probation department is having too large an influence on the sentence. The district attorney should have more influence on how that is, and I guarantee you would have public defenders and criminal defense attorneys who are saying that they should have more influence in a particular case. And it's an adversarial system, and even more so than the adult criminal system, the juvenile justice system there's more discretion at play because there are these gatekeepers, the juvenile probation officers, and there is less public oversight and scrutiny of most juvenile court cases because that's the way the system is designed for the reasons that LaRon explained earlier.
So another question, are there juvenile cases where the juveniles are tried as adults? And in what circumstances does that happen? And how is that justified?
Yes, there are circumstances where we move the court and ask for a juvenile case to be transferred to adult court. As some of you may know, after Prop 57 passed, the district attorney no longer has the ability to directly file those cases in adult court, so now we seek the court to do that, and we explain why we want that done. Ultimately, the probation department again writes a report recommending that the minor either stay in juvenile court or go to adult court. When we do that, we take into consideration a variety of issues. The minor's previous history, the seriousness of the offense, the circumstances and gravity of the offense, the sophistication of the minor, any previous attempts that the court has made to rehabilitate the minor. And I guess we justify it. Was that how do we justify that? I think, in my opinion, and I think probably many of the prosecutors in my office and around the state, there are some offenses and some offenders who have forfeited their right to be in the juvenile justice system based upon their behavior and the crimes that they commit. And so I do think in certain circumstances it's appropriate that they be removed from the community for a longer time than we would be permitted to do that in the juvenile justice system.
Here's a practical question. If your own son or daughter is arrested, would you advise them to assert their Fifth Amendment rights to not speak without an attorney present?
Yes.
And if your son or daughter is a youth of color, would you advise them the same?
Yes.
Okay. Let's see. Questions also about juvenile records. Having a felony at 17 years old, will he or she have to put that on their resume if they're applying for a job to report that they were convicted of a felony?
So that's a little nuanced. You're not convicted of a felony if you're under 18. You're not convicted of anything ever, and you can certainly say that. Realistically, depending upon who you're applying for a job with, they may or may not be able to find that out anyway. If you have not committed an offense, on the PowerPoint I listed the 707B offenses. Those are, again, the more serious offenses. You should be able to have your record sealed very quickly for free, and then you can really say that you don't have a record, because once your record is sealed, the court, the probation department, the police agency, the school district, anyone who ever had any knowledge of your record is supposed to seal their records. But even if you haven't committed a 707B offense and you haven't sealed your records, technically they're supposed to be confidential. But the reality of, in this day and age with everything being on the internet, it is probably likely that someone could find out if you don't go to the trouble of sealing your records. So I would definitely advise anyone to do that. But technically, just if you're asked if you've suffered a conviction as a juvenile, the answer can be no, because legally it is not a conviction.
Can you explain that distinction between a conviction and what you referred to as in your presentation for what it is?
A sustained petition. Yes. It's a term of art, which in reality, it came about because we want to think about the juvenile justice system as different, and that kids aren't criminals. They just make mistakes and they get rehabilitated, and so we don't want to give them that sort of stigma of having a conviction. So it's just a phrase that legally describes what happened. You have a petition sustained against you, but the conviction is something that only can be suffered by an adult. And so you should never have to say that you had a conviction if you were under 18.
I wanted to address, there was a recent survey in the Palo Alto School District around sexual harassment at its 2 high schools. And it found that there were relatively low rates of sexual harassment happening on campus, but also very low reporting rates. It was 88% of students who had experienced sexual harassment hadn't reported to anyone at school, and 81% hadn't reported to anyone outside of school. Are low reporting rates common in sexual misconduct cases sort of across the board? And is false reporting a common trend or not in sexual violence cases?
Well, and Nate may be able to speak to that from a police officer's perspective, but I would say it's not uncommon for any kind of sexual misconduct to be underreported. I think it's very, very common in all different kinds of sexual misconduct. And I don't remember the second half of the question.
Sorry, about if you see false reporting in sexual crimes?
I guess it's hard for me to say whether or not I see false reporting. If I get a police report and I don't believe that a crime has been committed, I'm not going to issue it. But I can't honestly say I can't really speak to whether or not I think false reporting is common.
Okay. Did you want to address the low reporting rates, or she covered it?
Well, I could say from my experience that, and I work, majority of my career has been in violent crimes. So I can say, and I'm currently assigned to our family violence unit, though that, for instance, is, in my opinion, tragically underreported. And in my experience in sexual assaults, particularly in sexual assaults involving minor victims, that's tragically underreported. That's my opinion. I'm not a statistician, but that's been my experience. I can tell you, I have personally worked numerous cases where I have spoken to victims, both adult victims and juvenile victims, who have lied to my face about a pattern of conduct that they were victims of that went over the course of many, many, many years, innumerable offenses committed to them that they flat out denied. And as an investigator, that's a very difficult dynamic to overcome. Part of the reason why these victims get into this sort of pattern of victimology is that it's usually committed by someone who's intimate to them. And so they're programmed by their victimization to not want to report on the person that's victimizing them. And I'm talking about interfamiliar, domestic violence, sexual abuse, and that's why sometimes this can go on for years and years and years, and law enforcement never knows about it. I've worked more cases than I care to remember that I can describe that way. I've also worked cases of people that have molested over 100 victims, 200 victims, and it's because of the insidious nature of those types of offenses. So to answer your question, do I think they're underreported? Absolutely. My opinion is they're absolutely underreported. To answer the other question I think you had was about false reporting. That's a very tricky topic for law enforcement, because nobody in law enforcement wants to be the cop who didn't believe a victim who had been victimized for years and years and years and years and years. And we know from our experience that they're reticent to talk to law enforcement to begin with. And so we're very delicate, I wouldn't even say delicate, we try to be as compassionate and thorough in our approach, knowing that we could be uncovering something that's not only extremely painful, but has been going on for many, many years, and that can be a very complicated process. So is there such a thing as false reporting to law enforcement? Absolutely. I've worked cases where the victims flat out manufactured a story for whatever reason. Would I say there is a great amount of that? I tend not to believe that. I think it's again, I'm not saying it doesn't happen. What I'm saying is that in my experience, victims of those types of very personal, very violent offenses are very reticent to talk about them at all, let alone to the bald male cop that's sitting across the desk from them. So again, I'm being repetitive, but I tend to think it's not, I don't think there's a large amount of false reporting in that way, if that answers your question.
Mm-hmm.
I think we can safely say that underreporting of sexual assault crimes happens. It's not just Officer Investigator Wandruff's opinion that sex crimes are underreported. Everything we know from social scientists to medical studies to anecdotal data, just everything we know, the stigmatization of victims, sexual crimes are underreported, and it's a fact. And yet we have to be aware of the fact that there are sometimes false allegations that are made as well. That's also a fact. It's nowhere near as big a problem as the underreporting. However, if there's someone who is innocent and falsely accused and convicted, that's anathema to our whole system of justice. But what we know now, because we've become more enlightened over the last few decades, is that sex crimes are vastly underreported. That's part of the cycle of victimization that investigator Wandruff talked about. That's why over the course of my career, I've been a prosecutor 23 years, I fought alongside many other people to get rid of the statute of limitations for rape and raping a child, which when I started, it was 6 years. And if the victim didn't come forward within 6 years, there was no justice, and the person that raped and molested the victim got away with it. And we know that sex offenders, more than general crime offenders, tend to recidivate. They tend to commit more and more crimes, and they tend not to age out of their criminality, some sex offenders, in the way that general crimes like robbery and assault, there's not a lot of old people that are committing those types of crimes, but it's different with sex crimes. So fortunately last year, the governor, Governor Brown, signed a law getting rid of the statute of limitations for the most serious sexual assault crimes, recognizing the fact that sex crimes are underreported. Elena, I also wanted to go back to a part of your question which talked about the survey that was done at the 2 local high schools. I would be very concerned if I'm concerned hearing that data, and if I was running any school and I learned that people were saying that they were the victims or they were sexually harassed but they didn't tell anyone about it, that would be a wake-up call to do more outreach and education within that community. That just seems somewhat commonsensical to me.
This is a question that's very relevant right now on college campuses. You can address it from your perspective. Do you believe that the burden of proof, i.e. beyond a reasonable doubt, should be eliminated in sex crimes?
No. No.
Can you elaborate?
No.
I'm not here to talk about colleges or schools, but I'm very familiar with our constitutional system of justice, and the enshrinement of the burden of proof is beyond a reasonable doubt. Doesn't mean beyond all possible or imaginary doubt, but it means that you ought to be extremely certain of what your determination is. And so I don't think it would be our opinion or advocacy that we should be lowering the burden of proof.
We got a few questions around juvenile incarceration. Does the time spent in juvenile hall go towards time served? So that would they take, if someone was in juvie for 8 months, would that time be taken off their sentence?
So generally speaking, no, and that's because most juvenile dispositions or sentences aren't time-based. The juvenile system, unlike the adult system, is based on rehabilitation as opposed to being just strictly based on punishment. So if you commit an adult crime and the sentence for that is 6 years in prison, that same crime isn't going to be you're not going to punish a juvenile by 6 years of anything. You're going to put them in some sort of a program, offer them services, see that they get counseling so that they stop doing that thing, but they're not just going to be locked up for a certain period of time. On the other hand, there are kids that have been in custody for significant periods of time pending their ultimate disposition, and clearly the court keeps in mind when they think about, should we make Johnny do 3 months or 6 months in some sort of a rehabilitative program, they will take that calculus into consideration, but ultimately it isn't a time-based disposition for kids.
And what are the responsibilities of juvenile probation officers to support appropriate re-entry care for youth returning to the community from juvenile hall?
I think it's very important. Generally speaking, when we have kids in custody, one of the most important things that the courts look at is what's in place for when the kids come out. And I think our judges in particular, and I think the district attorneys in court, we want to be sure if when they come out, and they're going to come out, whether it's a local facility or one that's far away or a state facility, we want them to not get into trouble again. And the best way to do that is to change the environment and whatever circumstances it was that brought them into the system in the first place. So yes, probation definitely tries to have services in place to make sure that when the child returns to the community, they have the counseling, the school, the supervision, and all the things that they need so that they can re-enter the community and not get in trouble again.
There's also a question about restraining orders and public access to restraining orders. Is there any public access to restraining orders? You know, if a student versus student restraining order, how are those monitored by the district attorney's office versus the school district?
So generally speaking, the district attorney's office doesn't monitor restraining orders.
Okay.
In any case, residential burglary, felony assault, sex crime, victims can request a restraining order of the juvenile court. And if someone has a restraining order and it happens to be a neighbor or someone at school, or the restraining order still applies. And it will be enforced in the same way whether the person is an adult or a juvenile. Generally speaking, when there are on-campus restraining orders, the school district can be made aware of those as a part of the disposition, because it falls into that category of in order to protect other vulnerable people. So the school district could be aware of that.
But it wouldn't be made publicly available in any way?
No.
Okay, and there are no exceptions to that?
No, because, well, it would be available, I suppose, if they happen to be one of those 676 listed offenses and somebody happened to be in the courtroom when it happened, but it isn't going to be something that's going to be publicized. It'll only be, that information will be provided to the extent that the school needs to enforce it.
Mm-hmm. There was a recent civil grand jury report about how long it takes Santa Clara County to conclude criminal prosecutions. Santa Clara County ranks last in resolving felony cases among the 49 counties in the state that were reporting data. So could you explain the typical time it takes for juvenile cases to wind their way through the courts and to be resolved, and how that affects the youth that are involved?
I think Santa Clara County ranked 57th out of 58 in terms of how slow Santa Clara County is. I don't know, maybe 47th sounded better than 57th. The civil grand jury report, as well as the response of the public defender's office and the response of the district attorney's office, are available online. And to the extent that people are concerned about delay in the criminal justice system, I would say go online and read those reports. That report and those statistics did not address or discuss the juvenile justice system. So it was completely separate. So for that answer, here's Ms. Dennis.
So thankfully, juvenile court hearings don't take anywhere near the kind of time that we're talking about. I would say generally speaking, on average, probably 30 days, unless it's a really serious case. That could be, up to 3 months or so. It's really unusual for a case to go on much longer than that. If it's a case where we are seeking to transfer the case to adult court, those cases typically take a significant amount of time longer. Those could be up to 9 to 12 months. But that generally is because we're talking about a lot of investigation when we're talking about really serious cases. We're also talking probably about experts, retaining an expert and having the minor interviewed and the family interviewed and anyone who has any knowledge about the minor and the victim and medical records. And so those kinds of cases get far more complicated and could take a long time, still not what the adult criminal cases take. But generally speaking, it should never take more than a month or two for a standard, if I could use that term, juvenile case to make its way through the system.
So we have a few minutes left. I just wanted to remind everyone in the audience, if you have questions, to get them on a card and we will address them. I was curious, what are the most common questions you get from parents of juvenile offenders?
Well, we don't often get to speak to the parents of the offenders. Sometimes they're the victims, and so then we do get to speak to them, but generally speaking, because the minors themselves have defense counsel, they and their parents don't usually want to talk. Well, we can't talk to the minors without their attorney's permission, and generally the parents don't want to speak to us unless they're the victim of an offense.
And even then, sometimes they don't want to.
Maybe especially then they don't want to talk to us.
Nate, maybe you could answer that as a police officer, former police officer.
So my job now, of course, I talk to people all the time. Pretty much my whole career. One of the questions is, why did you do that to my kid? But I think that's just a reaction that all parents have. Like, nobody wants to admit that their kid did something bad or maybe really bad. And so when the cops show up and and they're telling their parent why the kid's in handcuffs and now is going to be with us, the natural reaction of any parent would be, my kid didn't do that. So if I had to answer just numerically what's the most common response, that's clearly the most common response from any parent. And then, usually we spend some time explaining to the parent what happened, not only out of courtesy, but they're entitled to know, and I would want to know if it was something that happened to my kid. But without a doubt, that's the reaction. Is that what you asked?
Or are there common misunderstandings or confusion about the process that you encounter, or that you encountered with parents that they wanted to know more about?
There are some. Why didn't you contact? And again, it's dependent on what type of case it is. Sometimes they say, well, why didn't you talk to me first before you talked to my kid? That's a very common one. And that's a good question, and I would have the same if it was, again, if I was the parent in that scenario.
So police officers are not required to call a parent before interviewing a minor?
Well, the answer is it depends. And keep in mind, and that's a really evasive answer, but see if I can get my way out of this. You have to remember that police officers not only have to follow the law, but they have to follow their department's policy, which is very commonly more restrictive, believe it or not. And typically, the policies that I'm familiar with, typically the policy says something like, and I'm paraphrasing, if practicable, you should notify the parents prior to contacting and discussing or interviewing a juvenile. Suspect, victim, witness. And that's the general rule we follow, because parents are entitled to know what's going on with their kid. But there are myriad reasons why you wouldn't do that. I don't know if that answered your question, but for instance, very simply, sometimes juvenile offenders are not in the best of environments, for instance. Take a gang case, for instance. There may be in a household where there's a lot of gang activity. Their parents may be involved in it. They are either by harboring it or actively involved. That may be a consideration we make if I'm talking about talking to a 17-year-old offender who is a suspect in a drive-by shooting at a known gang house site. May be something I don't do. And again, there are a lot of factors. So it's not absolute. But a 13-year-old shoplifting suspect, there's a different set of considerations there. If that makes any sense.
That does make sense. Jay, you said something in your opening remarks I wanted to follow up on, the number of youth in juvenile hall. I think you said 300 from a few years ago down to 90. Is there a reason for that drop, and is that something that the DA's office is looking at or looking into?
It's something that we're really happy about, and so that was why I mentioned it. And I don't know what the percentage drop. I don't know what the percentage equals, but we certainly haven't seen any sort of correlating increase in crime as a result of the low population within juvenile hall. I think LaRon can address some of the reasons for that, but it includes, in the last several years, more focus on rehabilitation, more focus on diversion programs. That's that.
Well, yeah, I would just say the county worked really hard over a period of years. My predecessor in this position, Chris Ariola, worked with the public defender's office and the courts to try to reduce the number of kids that were incarcerated. And as Jay points out, it's a lot of things. It's finding diversionary programs. It's coming up with alternatives to detention. And I think we like to think that well, nationally, there's been a significant decrease in crime over the last few years, and I think that partly plays a role as well. But generally speaking, our county is pretty thoughtful about who needs to remain in custody.
In the state of California, there were 170,000 adults in prison 6 or 7 years ago, and now there's 120,000 adults in state prisons. So there's been a move in the state to transfer some responsibilities from the state level to the local level. But in this county, your district attorney, Jeff Rosen, is considered a reformer. He's considered a progressive district attorney. He doesn't believe that it's a good thing for anyone to be in juvenile hall unless they are so dangerous that they need to be in juvenile hall and there's no other place for them. And in a county of 2 million residents, we're going to have people that are so dangerous and they're such a threat to public safety that they need to be in juvenile hall and there's no other alternative. And right now that number today is 89.
Before we wrap up, I just want to see if there are any other audience questions. No? One more, can we just take questions from the crowd? Sure.
Go ahead.
As a probation officer, isn't it, I guess, kind of your job to get to know the inmate?
So the question.
Yes. So they're the ones that's going to make the recommendation for release or
Right. Yes. So the question was, as a probation officer, isn't the role of the probation officer to get to know the minor in question? And since they're making the recommendations, obviously they're the perfect person to do that. And yes, as a probation officer, they are responsible for interviewing the minor, the parents, the victim. They go and check on the kids' school records. They check on their mental health records. They do what's called a needs assessment. So yes, the probation officer is the person who gets to know the minor, hopefully the best. To some extent, I think their public defender probably also knows them really well. But probation is also well-versed in what's available for the minor in the community in terms of rehabilitative services. And because they do that needs assessment, what do we think will work best when trying to formulate a dispositional plan to work with the minor? So probation's definitely in the best position for that, yes.
Yes.
What's the caseload for juvenile probation officers?
Well, if I had to guess, and I haven't asked them this in a while, back when I was a probation officer, it was typical you'd have about 60 kids per probation officer. But that was back when we had 300 kids in juvenile hall. So I would say now they probably are much closer to maybe 15, 20 at the most. I mean, I think their caseloads are smaller, which is a good thing because I think that the practice has developed such that they need to spend more quality time with the kids, and when you have 60 on your caseload, you just can't do that. So, and it also depends on the type of supervision. Some probation officers are supervising kids that are involved in gangs and they have a much higher need. Those kids are on a caseload that's much smaller than maybe just a general supervision caseload.
I think there's one more question.
Jay and Ms. Dennis, in reference to gang enhancements, would it be fair to say that they come out of communities, youth that are charged out of under-resourced communities, and there is an argument to be made, therefore, that they're racially discriminatory by their very nature? And my question is, I know that the office has done a lot of work on racial discrimination and filing practices, but more specifically in reference to juvenile cases, what are you all doing to try to eliminate long gang enhancements where they come out of communities where the resources aren't there, the school systems aren't giving the funds, et cetera, et cetera?
Well, I think if we have another hour and a half, we can get into detail about that. But I'll try to answer it seriously and not glibly. And the answer is that all crime, or the vast majority of crime in our community, in our county, in our state, in our country, comes from communities and areas that are under-resourced. Then you ask a more complicating factor, what role does race or racism play? Well, does that play a role in why those communities are under-resourced?
what came first, the chicken or the egg? So it's a very complicated question. It's a sophisticated question, as you know. You're a sophisticated person, and I don't have a way to answer that.
Well, in terms of the mechanics of the filing of gang enhancements, so that you minimize that, particularly if you were.
So let me,
You made a good argument that the mental capacity is not fully formed. So when you're adding a 5 or 10-year potential gang enhancement on a juvenile, it's a really important thing to look at.
let me answer the question this way. Much of what law enforcement and prosecutors do is reactive. Something horrible has happened. There's been a drive-by shooting that resulted in a murder. It was done because the person that did it thought they were advancing themselves within their gang. A gang enhancement is filed because we think that that's necessary to reflect the seriousness of the crime, and what that means is that the person who's been convicted of doing that beyond a reasonable doubt by 12 people unanimously, that person will be held in prison perhaps for their entire life. That's a reactive response to something tragic that happened, and I think that that is a significant primary and important role for law enforcement and district attorney's offices to play. However, there's another role that law enforcement and district attorney's offices can play, and that is to be proactive and not simply reactive. It's to be part of the communities that they serve, to be guardians within the communities, protecting people, and not sort of warriors within the communities that they're serving. So we have proactive programs in the district attorney's office. There's brochures over on the table there for the Parent Project, which classes are held in at least 3 languages throughout the county to give parents the tools if they're having problems with their 12 and 13-year-old who might be getting involved in a gang. They can enroll in a Parent Project class, and that's a more proactive approach that we're doing. I'd like to think that some of the diversion programs that we do in the county, while that's reactive to certain things, it's also proactive so that we're not just warehousing people, we're trying to solve problems.
Okay, well, I think that about does it. Thank you all so much for coming tonight, and thank you to our panelists.